To trigger the court's inherent powers, the party moving for sanctions must show subjective bad faith. Hyde versus Irish, 962 F, 3D 1306, 1310, 11th to 2020, that mean, S. Showing intentional and not just reckless behavior, J.C. Penney Corporation, Incorporated, versus Oxford Mall, IIC, 100 F 4th 1340, 1346, 11th to 2024, citing purchasing power, Lick v. Blueston Brands, Incorporated, 851 F 3D 1218, pages 1224 to 25, 11th to 2017. This showing can be done with either 1 direct evidence of subjective bad faith or 2 evidence of conduct so egregious that it could only be committed in bad faith. Hyde, 962 F, 3D at 1310, quoting purchasing power, 851 F, 3D at 1224-25. Once a showing of subjective bad faith is made, the full force of the court's inherent powers is unleashed, and the court can utilize its discretion to impose wide-ranging sanctions against any offending party for a full range of litigation abuses. Mingo versus Sugar Cane Growers Co-op of Salar, 864 F, 2D 101, 102, 11th to 1989. The sanctions imposed can range from a simple reprimand to an order dismissing the action without prejudice. In re Sunshine G. Stores, Incorporated, 456 F, 3D 1291, 1304 111th to 2006. Federal courts have the inherent power to impose sanctions on parties, lawyers, or both. Chambers, 501 U.S. at 46. T. The inherent power extends to a full range of litigation abuses. Because of their very potency, inherent powers must be exercised with restraint and discretion, and a primary aspect of that discretion is the ability to fashion an appropriate sanction for which abuses the judicial process. Chambers, 501 U.S. at 4445. C. 28 U.S.C.S. 1927 Title 28, Section 1927 provides that any attorney or other person admitted to conduct cases in any court of the United States or any territory thereof who so multiplies the proceedings in any case and vexatiously may be required by the court to satisfy personally the excess costs, expenses, and attorney's fees reasonably incurred because of such 28 U.S.C. $1,927. T. The plain language of the statute imposes 3 essential requirements for an award of sanctions under 1927. First, the attorney must engage in unreasonable and vexatious conduct. Second, unreasonable vexatious conduct must be conduct that multiplies proceedings. Finally, the dollar amount of the sanction must bear a financial nexus to the excess proceedings, that is, the sanction may not exceed the costs, expenses, and attorney's fees reasonably incurred because of such conduct. Amlong and Amlong, P.A. v. Denny's, Incorporated, 500 F, 3D 1230, 1239, 11th to 2007. To trigger $1,927, the party moving for sanctions must show objective bad faith, which usually means showing the attorney acted knowingly or recklessly. Hyde, 962 F, 3D at 1310, quoting Schwartz versus Millionaire, Incorporated, 341 F 3D 1220, 1225, 11th to 2003. The court next addresses the conduct alleged in each motion, the court's relevant factual findings, and the imposition of sanctions, if any. A. Trainer's Rule 11 motion for sanctions against Chiapetta. 1. Allegations of misconduct. Trainer's motion for sanctions, doc number 202, alleges that Chiapetta committed a fraud upon this court when he attached declaration of James McGibney to his response against a motion to dismiss because Chiapetta knew or should have known that the declaration falsely states that Irena conspired with Joseph Camp to use emails, telephones, and social media posts to threaten and harass a process serve R and her company, We Serve NJ, Lick ID, at page 1. Irena continues that the McGibney declaration falsely states Trainer conspired to harass We Serve, which Chiapetta knew was false. ID, at page 2. Trainer asserts Chiapetta filed the declaration arguing that it is proof of a pattern of conduct, through which this court can imply that Trainer participated in a civil conspiracy against Nushirvan. ID. Trainer asserts that the McGibney declaration statements about Trainer are completely fabricated and are a component of Chiapetta's ongoing efforts to socially engineer a non-existent conspiracy against Nushirvan. ID. Footnote omitted. Court's factual findings. The McGibney declaration was originally filed in case number 23 CV 340 and was later attached as an exhibit to Chiapetta's response in opposition to defendant's motion to dismiss the operative pleading in the current case. Doc number 17010. Chiapetta attached a declaration to support his argument that a civil conspiracy was sufficiently pled because conspiracy could be implied or inferred through a pattern of conduct. Doc number 170 at page 17. Most of the McGibney declaration addresses McGibney's own actions and the alleged actions of Cap. Only one paragraph mentions harassment of a process server. Lastly, I would like to bring to the court's attention an incident that occurred on February 6th. Upon discovering that I served Mr. Trainer with a letter misrepresentations court, Mr. immediately began to harass the process server. Attached the process server's affidavit to my affidavit. Doc number 17010, I-22, to the supporting affidavits detail Camp's alleged harassment, but do not mention Trainer. See docs number 17011, 12. The court finds the McGibney declaration pertinently asserts 3 facts. 1. That Trainer was served with a letter. 2. That Cap learned of the service. And 3. That Cap immediately began to harass the process server. Doc number 17010, I-22, 4 days to plaintiff labeled this exhibit as Exhibit J. However, the exhibit appears on the court's CMECF system as Exhibit 10, though herein by the numerical number assigned to it by the court's CMECE system. The McGibney declaration was filed in this case. Trainer served Chiapetta a Rule 11 safe harbor letter, Doc 202, page 7, in which Trainer demanded Chiapetta move to strike the McGibney declaration or face a Rule 11 motion. See Doc number 202-7. Chiapetta never moved to strike the McGibney declaration, and Trainer filed the Rule 11 motion more than 21 days after serving the safe harbor letter. 3. Appropriateness of sanctions. Trainer's motion requests the court strike the falsely sworn McGibney declaration. 7. sanction Child Petter and grant defendants such other and further relief as the court deems just. Doc number 202, p. 22. Because a letter does not satisfy Rule 11's safe harbor requirement and the pertinent factual claims made in the McGibney Declaration are not objectively frivolous, Trainer's motion fails both procedurally and substantively and no relief is warranted. 3. Trainer's motion for Rule 11 sanctions fails procedurally because the letter Trainer sent to Child Petter does not satisfy 3. Like Trainer's request for sanctions, his request to strike is not merited. A full 3 weeks before Trainer sought to strike the declaration, the court denied another defendant's request for the same exact relief. See Doc number 193. The order explained that the civil action ordering effect required discussion of specific cases and the rationale when a party moves to strike, and because that motion did not contain that required discussion, it was unnecessary and without legal support. Doc number 193, page 3. Trainer's motion commits the same error and merits the same result. Plus, because the motion to dismiss was decided without affording any weight to the declaration, Doc number 420, page 18 in 4. Trainer's request to strike the declaration is moot minor.